Hey everyone, Harry here to talk about the up-to-the-minute state of play involving the release of the Jack Smith report. The development this morning is an order by Judge Eileen Cannon. Now, her very participation in this case is a bit of a mystery. She entered that order before that not only said the DOJ couldn't look at or do anything with it, but that also purported to last and not expire until 3 days after the 11th Circuit had ruled on Nauta and de Oliveira, which really means Trump, emergency motion. Where do you get off saying after the 11th Circuit rules, it's an extra 3 days? Nowhere, and it's just complete activist and placating of Trump kind of addition. 3 days now, when we're really going down to the wire, matters a lot. Nevertheless, by its terms, her injunction doesn't expire until tonight at midnight, Monday night, and in her order issued today, she made it clear that that injunction remains in place. Now, it's very dubious how she gets off doing anything in this case. As I said, she already dismissed the whole case on the ground that Jack Smith lacked authority, and that issue and the whole sort of case file is now with the 11th Circuit. Nevertheless, you have this embarrassing fact of an order that purports to bind DOJ and as to the whole country just out there. And so it can't be completely ignored. And the department hasn't completely ignored it, although reading between the lines of its various submissions, it seems clear that the department is basically indifferent in the sense that it sees, in terms of its own plans, no practical impediment presented by Cannon. But the 11th Circuit, when it denied the emergency motion for relief by Nauta and de Oliveira, and from now on I'll just say Trump. Trump actually has not been, it's kind of important, she went so quickly to issue the injunction, his motion to intervene hasn't been granted. He's officially not in the case, he's just an amicus. But he's obviously calling the shots. Anyway, so the 11th Circuit, they asked for emergency relief. The 11th Circuit says no, but at the same time, even though in its answering papers, the DOJ had basically said, dissolve the injunction from Cannon, the 11th Circuit said, you got to ask us more directly, file a notice of appeal from what Cannon has done. And the DOJ now has done that. And if the 11th Circuit acts on it, say today, that will supersede any of this nonsense from Cannon. But if they don't, the state of play is Cannon, in her latest order, recognizes she has no business trying to interfere with what the Attorney General, not even Jack Smith, he's gone now. He resigned quietly on Friday. So she has no business trying to tell Merrick Garland he can't release Volume 1. She ordered the department to represent whether there was anything in Volume 1 about Nauta and de Oliveira, because it is the case. The department recognizes, you can't say all this stuff about them while the case as to them is still pending. The department said no, just a couple bland cross references, and on the basis of that, and even though she shouldn't have demanded it of the department, she should have demanded it of Trump, who's the one seeking emergency relief. Nevertheless, based on that, she says, okay, Volume 1 can go out. Volume 2, now the department has said it won't release it to the public while the cases are pending still against de Oliveira and Nauta. And the department agrees to that. That's a general principle. You can't do a report while it's still pending. It could prejudice the current defendants. And it's raised the intriguing prospect that in the few days remaining, the department actually will move to dismiss those two from the case, close down the whole case, and on that basis say, okay, we're ready to release volume 2 of the report. They don't want to do it prematurely because the hope is that their appeal from Cannon's order, which about no authority for Jack Smith to act, which was A, crazy, and B, completely out of step with court after court, including the U.S. Supreme Court in a unanimous opinion, have said it would be nice to get that reversed. It would be in the DOJ's general interest if they want to have special counsels, and who knows when the Trump team comes to town if they will see it that way or if they'll be just completely myopic because they like Cannon's having dismissed the case on this basis against Trump. Anyway, Cannon says, okay, I got nothing to do with volume 1. Let me complete that. What that means is she drops a little line in the end, saying the injunction's still in place, but the injunction by its own improper, unlawful terms, that extra 3 days from the 11th Circuit, expires at midnight tonight. So as of 12:01, unless something happens, and I'll move to that shortly, there's no impediment and the DOJ can simply release the report, and I think it will. If nothing else happens, I think stand by at midnight East Coast time for the release of Volume 1. On Volume 2, what the department has said, we won't release it publicly, but we will, as we need to, give a kind of redacted copy and review and discussion with the 4 big shots in Congress who oversee the DOJ and whom the regulation sort of references: the top Republican, top Democrat, top Republican, top Democrat in the House and Senate, respectfully, on oversight. And Cannon, intermeddling as ever, says, you can't do that. We need to have a hearing because even that much might violate Nauta and de Oliveira's rights. I'll see you for a hearing on Friday, the 17th, 3 days before Trump is set to take office, and then we'll decide whether or not you can release Volume 2 even to Congress. That matters, A, because it's crazy, but also B, it's important for the department in some way not to leave town with all copies of the report within DOJ where Trump and his minions can simply shred them all. So it's really vital to the sort of historic interest in this report's coming out eventually that a copy is lodged somewhere. Maybe the president could request it and just disseminated with the immunity opinion. There's nothing they could do to him. Or it could be lodged in a court. It could be lodged with Congress. Something like that, I think, really needs to happen, lest the Trump team comes in and just literally tries to erase it from history. But the other point about Volume 2, as I've mentioned, is if they dismiss the case as to Nauta and de Oliveira, they may reason Trump's going to pardon him as soon as he comes in, and we're not going to get this opinion on the merits from the 11th Circuit, so let's take care of releasing Volume 2 by getting rid of them and see if anyone tries to stop us. You could see that happening. The final point is on the other side. So once this expires, Cannon had actually issued this latest order because Trump and Nauta and de Oliveira had come in improperly. It's improper for the judge to answer the call saying, just extend your illegal injunction, please, Judge Cannon, so we can talk about this. And it's on that basis that Cannon issues this with a response from DOJ that basically says you can't do anything. But let's say the 11th Circuit comes down and reverses the injunction that Cannon entered a week ago, and with this extra 3 days, or otherwise it just expires, so the coast is clear on Volume 1. Now the next question is, will Trump try his luck again at the U.S. Supreme Court? You submitted, I think, to Justice Thomas, who's the circuit justice for the 11th Circuit. He would probably grant an administrative stay while he serves it up to his the 8 other justices. That's not improper in and of itself. That's how you would handle something like this. But will Trump try to take it to the Supreme Court and have them stop the public release of Volume 1 of the report And the short point to make here is there is not a legal basis under the sun for doing that. It's got nothing to do with a pending case. It's totally Merrick Garland's power under the regulations and his relation with Congress. They would be completely lawless in doing it. But you may have, well, we saw 4 who were ready to grant a stay on the sentencing. And if all they want to do is sort of close things down long enough to think about the issue, as it were, they could get Trump over the finish line of January 20th. It would be an outrage. But that's the other thing to keep our eye on is whether Trump, come midnight or before midnight, or if the 11th Circuit were to rule, himself makes an extra play either to the 11th Circuit as a whole, en banc, as they say, or the U.S. Supreme Court, and whether, even though that's totally meritless, he is somehow able to get away with enough of a stall that it comes to January 20th when he takes total charge. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.